Good afternoon. We are so honored that we are going to have real attorney Ramey Ko, and he is specialized in so many areas: immigrations, helping people set up business structure, and also he also have a lot of experience dealing with real estate. And so today we're just, I know we all know attorneys can help us to deal with so many law related or regulation questions, but today we are just going to tackle down with real estate investment, landlord and tenants, some of the things that we need to pay attention to, or some of the landlord-tenant relationships, the areas we can, we can just prevent or take care of it. So we are going to give the rest of time to Attorney Ramey to help us to talk more about this area.
Thank you so much, Doreen. It's a real pleasure to be here. And so I know this is a big area, and so we're just going to touch on a few topics today to help people kind of get a sense of, I think, the things to pay attention to. So why don't we talk about landlord-tenant issues first? I know a lot of the folks that work with Doreen and Dee Dee and follow them have at least one or two rental properties or investment properties. And particularly in the Central Texas, Austin area where the rental market is so hot, it can actually be a really good way to invest your money, particularly if your strategy is to hold properties for a period of time. The problem, of course, is that when we're not professional landlords, when we're people who just own one or two properties, we often don't have anybody to teach us a lot of the legal issues that we have to pay attention to. Now, using property management companies and brokers and realtors can be very helpful, right? But as landlords, ultimately, you have legal liability when it comes to your property, and ultimately, you need to know what your obligations are. So just a few tips, the things that I encounter frequently dealing with my clients and knowing the problems that come up a lot. First tip, first and foremost, easiest thing to do, but something that very few people do, read your lease, right? Even if your property management is providing the lease for you and handling all of that, you should sit down and read through it at some point because you need to understand what is actually in it. I can't tell you how many times, probably more than half of the time, I get questions from landlords and tenants. All they would have to do to answer that question is look at the lease. The question is answered in the lease. And a lot of times when they're unhappy or upset, it's because they didn't know it was in the lease, right? And then they're even more upset because they realize there's nothing they can do about it now because they agreed to something, right? So, quick, a couple easy examples of things people miss. If you're leasing commercial property, if you're a restaurant owner or something like that, most commercial leases say that fixtures, anything you install into the property, right? And anything that would leave a hole if you were to pull it out. So air conditioning units, stoves, walk-in freezers, things like that. Those are the property of the landlord when your lease ends. You don't get to take those with you. Right? And a lot of people that I deal with, a lot of clients are very surprised and shocked by this. And it can often be the source of problems because sometimes somebody come to me and they'll say, oh, we ripped out all the AC units and now the landlord's suing us. And I have to tell them, you know what, the landlord's right because your lease explicitly stated this. And in the residential leasing context, it's the same thing. People often don't read about trip charges, repair costs, the obligation that you have to be available when somebody is coming out. As a landlord, right, a lot of times you don't understand that when things are very urgent, health or safety threats, right, sometimes you have to address it right away, even if that means you're going to have to pay more money or you're not going to be able to get the best possible deal because the potential liability you face for not addressing the issue it could be much greater. Right? And so security deposits, another area where I see frequent problems, right? So a lot of people don't realize when the tenant moves out, you have 30 days, 30 calendar days to provide a written, itemized statement, right, of all the charges and deductions. And you can only deduct for things that are over and above normal wear and tear, right? So if you replace the carpet just because the carpet's old, right, you can't charge the tenant for that, right? If the tenant damaged the carpet, yes, you can charge for that, right? But you have to have that broken down. You have to have that to the tenant in 30 days, right? On the tenant side, a lot of tenants don't realize that that 30 days doesn't begin to run until you move out and you provide a written forwarding address to your landlord. If you don't provide that written forwarding address, that obligation doesn't start. So if you wait a month to provide that written forwarding address, your landlord gets another 30 days from that day to return your deposit. So these are just, you know, a few small areas, but I think the areas that come up a lot: repairs, right? Pay attention to what the law really requires. Right? 7 days is the presumed reasonable time for getting something done. If it takes more than that, you have to provide an explanation as to why, and it has to be reasonable. Right? Now, for
the 7 days is not really actually complete the repair.
It's 7 days to take reasonable steps to address it. Good. And the 7 days is also not a hard and fast rule, right? It's what we call a presumption in the law. That means that the law says that under most circumstances, we assume 7 days is reasonable. But you can always, as a landlord or tenant, argue why 7 days doesn't make sense. If it's a threat to health or safety, so for example, if you have literally no running water, right? Then you're probably not going to get 7 days to address that, because that's a much more urgent issue. If you have sewage backing up into the unit, right? That's something you got to address right away, right? And then when it comes to heat and AC, right? This is an area where there's a lot of confusion, right? Texas, unlike a lot of other states, doesn't have a hard and fast law. Many states in this country, and if you're from somewhere else besides Texas, you're used to this, say that if the temperature is over a certain amount, then AC repairs are emergencies. If it's below, then heating repairs are emergencies. We don't have that rule in Texas. Good. There's no magic number. But that's not necessarily a good thing, because that means that you can always argue the situation, right? So that means you have to be very careful about the situation, right? My general rule of thumb is if it's going to be more than 85 degrees inside for more than a day, then you're looking at a you're looking at an emergency situation. But then you also have to take into account: are there children? Are there elderly? Are there people with disabilities or ill people in the home? Right? These are all things you have to consider. Americans with Disabilities Act, right? Huge area, much more than I can go into. But the part that a lot of landlords don't seem to understand is that you must provide reasonable accommodation for people who have disabilities. Now, you can require they pay for it, right? That's fine, as long as it's reasonable. But if somebody wants to rent, and if they have a disability, you cannot say no to them simply because you don't want to deal with the hassle or the problem. And the area where a lot of landlords are having problem with this these days is with a more recent trend, which is emotional support animals. Service animals, service dogs. People are used to seeing eye dogs. They understand, oh yeah, that person's blind, they have a seeing eye dog, I have to allow them to have that dog. But some people have, now that we have a better understanding and we're making more progress in mental health, right? Some people have doctors who have actually prescribed them, have told them to have an animal as a companion to provide emotional support. And so this qualifies if there's obviously it's fine to ask for doctor's letter or something like that, but if they have a diagnosed condition and this is something they need, that qualifies as a disability. And that means that whatever rules you normally have with pets have to be modified with respect to that applicant. So all of these are small things, but at the same time they can add up, right? They're little things that are very common and pop up a lot, and it's very easy to miss them or to accidentally misconstrue or misunderstand what your obligations are. So whether you're a landlord or a tenant, these are things really important to pay attention to.
Okay, good. Yeah, these are very, Austin 101 also provide property management service as well. So what Ramey just told us about all these small tips. Yes, it is true. It's just like we deal with so much secure deposit refunds, service animals, these contracts. A lot of times we really just, as Ramey said, they say, okay, we need to go back to read what these contracts says. All of these small tips. And you know, when we're returning secure deposit, it's like what's the normal wear and tear. It's also a gray areas. Like so many people we need to provide extra explanations or try to dig deeper. For speaking of landlord and tenant relationships, one thing once in a while will come up is eviction.
Right.
Yeah.
So yeah, I mean, evictions are an unfortunate, reality of life. It's something we hate to have to deal with, but a lot of people we can't avoid it. And so one thing that's really important to remember is that eviction is a very specific and technical legal process.
Yes, it is.
And with especially with residential evictions. Commercial evictions are a little simpler and easier because it's assumed that if you're a business, you're what's called a sophisticated party. You have an understanding. Now in reality, I can tell you I have many clients who own businesses who are far less sophisticated than you know residential tenants that I have clients of.
Yeah.
So, but that's the assumption. So in a residential context, when you evict somebody, there are lots of steps you have to take, lots of protections, and they're very, very tricky, right? So for example, the notice to vacate, right? So one thing to remember is that evictions have to be handled judicially. You cannot do it on your own. You cannot go and change the locks and remove the furniture and try to kick the tenant out on your own. If you do that, you will be in huge trouble and you will have enormous liability. And the police could even get involved in some situations, right? So you do not want to ever try to do what we call self-help, right? In an eviction context. If you follow the judicial process, the first thing you have to do is give a notice to vacate. You have to send your client a written notice. It has to be sent in certain ways. If you're posted on the door, it has to be posted on the inside of the front entrance door, not the outside, right? The only time you're allowed to post it on the outside is if the door has a deadbolt lock that cannot be unlocked from the outside, or there may be a dangerous animal inside. Then you can post it on the front door. But if you post it on the front door, you also have to mail a copy to the client, right? And so, to the tenant rather. And so, this is something that a lot of people miss. Now, notice periods. This is where you have to read your lease. Sometimes it's 3 days, sometimes it's 24 hours. Texas law says that if the lease doesn't say, it's 3 days. If the lease says a different period, the shortest it can be is 24 hours. You cannot have less than a 24-hour notice period. What does that mean? That means that once the tenant is given the notice, you have to give them at least 24 hours under a 24-hour notice, or 3 days under a 3-day notice, to move out on their own, right? And if they move out on their own, then that's that. You can't file to evict them. Now, if they owe rent, you could certainly file against them to sue for the owed rent, but there's no eviction there because they're gone. Now, if they're still not gone, right, then at that point you're allowed to file an eviction in Justice of the Peace Court. That's the court it goes into, and then you go through the legal process, and it's a trial and everything like that. They're usually very short, but it's still, it's still a trial process. One thing a lot of mistake people make with the notices to vacate is that they must be unequivocal, right? A lot of landlords will send these notices that say, you owe this much rent. You either pay this rent or move out in 3 days. That is not a valid notice to vacate. You cannot have a notice to vacate that is conditional. If it says that you can do certain things to avoid having to vacate, then it's no longer considered a notice to vacate. So that means if you're going to evict somebody, right, you must do the notice as just a straight, you violated the lease, you must move out within a certain number of days.
Good.
And really, you don't want to go into a heavy amount of detail in those notices.
Okay.
Right? The primary thing you communicate in the notices is that they're being asked to leave. They're being asked to leave because they broke the lease in some way, right? And to tell them how many days they have to do it, whether it's 24 hours or 3 days, depending on the notice. But that's where you see a lot of people mess up. Another area where you see a lot of people mess up, if a landlord if you have set up a kind of business entity where you have a DBA in order to own the property, that DBA must be on file right, with the county that the property is in and with the Texas Secretary of State. People often forget to file the DBA with the Texas Secretary of State. They only file in the county. And under the law, I can ask the lawsuit, and I used to represent a lot of low-income tenants when I worked for Legal Aid. Frequently, we used this tactic. We would look up to see if that DBA was on file with the Secretary of State. And if it wasn't, we can tell the court that they have to hold off on the lawsuit until the correct paperwork filings are done. And so that means that we're talking, and then every time you reschedule something in court, they're not going to reschedule it for the next day. They're going to reschedule it for a few weeks out. So we're talking about potentially a month or more of additional lost rent because you forget to do that kind of thing. So this is just to kind of touch on the area of if you have a business structure set up for your investment properties, and you really should, because if you get sued by a tenant and you just own it in your own name, you are personally liable, right? That means that they can take the money out of your pocket, right? Versus if you have a company set up, then you limit the liability to that company. So if you do that, make sure that you're doing all of the things you need to do to legally maintain that business, right? If that business isn't in the proper form, structure, if you lack the correct governance documents, this is another area where you see a lot of problems. A lot of people think, oh, I just need to file that certificate of formation with the Secretary of State and I'm done. And they don't realize that's actually only step one. And it's actually the least important step. if you just file that, you don't have bylaws or an operating agreement, you don't have company meeting minutes, resolutions, votes, record votes of the members, ledgers, certificates, these types of things, then your company could be very easily considered a fake or fraudulent company, and therefore you would lose those protections. So if you're going to be investing in real estate, whether for rental properties or even because, in a different model, if you're going to be flipping houses, if you're going to be investing with other investors to buy and sell, or to develop properties, things like that, it's very important that you have the proper business structures set up. So the other area I frequently work on is I help landlords set up ownership structures for their properties, and I also help real estate development projects set up the structures for how they're going to develop. So for example, in a development project, you're usually going to have several partners. You have a developer, you might have somebody who's providing the land, and then you will usually have some kind of financing vehicle, right, where the investors are putting in the money. And so these are all different entities that are typically set up, and then they are joined together typically in some other entity, like a partnership of some kind. And that's a very common way we do commercial and residential real estate development here in Central Texas. People like it because it makes investing simple, because you just have to invest in the one company rather than the whole project, and that company keeps track of everything for you and then just distributes the investors. The rest of the project, the developers and stuff, they don't have to worry about that part. They can just focus on construction, permitting, all that kind of stuff. But these are all kind of interrelated issues. So whether you're a small scale investor and just have one or two rental properties, and that's pretty much what you're going to do, or whether you're somebody who's looking to own multiple properties, maybe looking to even set up larger investment projects and things like that to own, buy, sell, develop properties, then it's really important in any of these situations to make sure you have the right legal information and advice. You know, it's you know, and somebody with one or two properties, you know, you're probably not going to need as much, right? Consulting a lawyer every now and then, getting some funding every now and then, you know, is probably sufficient. But if you have a larger project, you're probably going to have more needs. But even the smallest investor is well served by putting some investment in law. I always tell people, when people think about lawyer fees, right? And I always endeavor to make them reasonable, and I think most lawyers try to do that. Not to say that there aren't lawyers out there who don't behave well, but the money often looks like a lot until you get in trouble. Until you realize, wow, I could have avoided all of this liability if I had just paid a little bit more up front. So I always tell people, it's like insurance, right? If you're going to invest, and I always tell people this, it's funny, I'll talk to somebody who says, oh, I'm investing, you know, $500,000 of my own money in this startup company, but I don't want to spend more than $300 on an attorney. And it's like you're spending $500,000 of your money, but you don't want to spend $300 to protect that investment, and you know, more than $300, right? So if an attorney says, you know, it's $1,000 or $2,000 to set up something, help you structure something, it could sound like a lot up front, but when you realize that the cases when I have clients come in who are coming to me when something has gone wrong because they didn't do what's before, they're definitely looking at much more money than that. Right? Your legal fees are always going to be more if there's some dispute to work out, and on top of that, most cases are going to have some kind of settlement. There's very rarely a situation where some money is not going to be changing hands. So, you know, it's one of those things where it's worth the investment up front.
Yes, definitely.
A good attorney, a good accountant, you know, a good realtor. These are all very, very key things. And again, you might feel like, hey, you know, this might be, I may end up spending $3 or $4 grand more up front in cost than I had originally planned or had wanted. But I guarantee you, right, that'll give you a peace of mind that's worth a lot. That'll make a lot of things that happen in the future easier to deal with, and it'll avoid the worst problems and the worst situations. There's never 100% guarantee, right? No lawyer, no accountant, nobody can protect you 100%, but it's a matter of how much can I insure myself, how much can I protect myself, so that this, you know, baby of yours, right? Your money, your hard-earned money, your project, your dream, your entrepreneur, real spirit or vision, right? It's important to keep that protected.
Yes. Okay, good. We so appreciate Ramey just really spend so much time with us, really talk about protections and different strategies to keep yourself, or how to set up your investment or LLC or your entities right to protect yourself. we thank you for his time, and maybe in the future we will invite him come back and to talk about different professional field. We appreciate it.
And just to add a quick disclaimer that all the information we discussed today is simply informational.
Yes.
None of this should be considered legal advice. Legal advice can only be provided if I speak with you specifically about a specific issue. If anybody needs legal advice, then you need to consult your own attorney. You cannot rely on what we talked about today. This was just general information, general applicability. Everybody's situation is different.
Yes.
You know, even the most routine situation will have unique factors. So again, this is not legal advice today. I'm not serving as your attorney in providing this information. So if you do want more specific information for your situation, then please consult an attorney.
Yes, and for any information we talk, if you have some further questions, you can always contact Ramey over here. Okay, thank you for watching.
Thank you.
Thank you. Bye-bye.